Okay, joining us again, as always, is our legal analyst for the Karen Reed trial, Katherine Loftus. And today we're talking about motions in limine, a lot of them.
Lots of motions in limine.
Let's start with motions in limine, a very legal term. What is it?
The easiest way possible is it kind of clears up the issues of confusion before we go to trial. So we don't have to worry about in the middle of trial an objection or a question and the judge deciding it then. These are issues that both the defense and the Commonwealth has the ability to raise, that they think this is likely to be a point of contention. We don't know if we are going to be able to ask these kinds of questions. So let's inquire of the court prior to the trial starting so that we can sort of clear the plate of these issues.
So is it kind of fair to say it's like setting some of the ground rules ahead of the trial?
It is, because it really what happens in motions in limine is sometimes they can be allowed as a matter of course, sometimes they can be allowed in part, denied in part. The court can specify as to what kinds of questioning the lawyers can ask. So it really sort of parses down the issues to make everything in sort of the goal of judicial economy to move faster.
Makes sense. Okay, before I get into the actual motions in limine, I have to ask you about this term because I don't know what it is. There are two different motions about chalk.
So a chalk is basically a demonstrative aid. I don't know why we use these weird words in the law, but there are always, it's either legalese or words that don't really make any sense. I mean, really what it used to be is that you would have a chalkboard in the court before we had whiteboards or before we had Elmo machines, which is generally what we saw when the exhibits were pulled up or anything like that. We saw it on the big TV. But what chalks usually are essentially big poster boards with data, timelines, whatever relevant information that the attorneys want to use through the witness to show the jury, simplify it down. And sometimes, a lot of us are visual learners. So that's what they do. They're basically visual aids to support what the testimony is.
Okay, makes sense. A display of sorts.
That's correct.
Okay. I'll get into the things that we had said we would talk about now. And just so our viewers who are watching this know, there's more than a dozen motions. Some of them from both the prosecution and the defense are two sides of the same issue. So we'll try and go through some of the main ones. I want to start with ARCA. We've talked a lot about ARCA anyway. There are still unresolved issues. Like the judge has still not decided on the whole allegation of Alan Jackson making misrepresentations to her. But there's multiple motions in here about ARCA. The Commonwealth wants to be able to tell jurors that the defense paid these guys. And then the defense wants to be able to tell not only not say we paid them, but also tell jurors that the feds hired them.
Right. It's a little bit complicated. I think given that, so the initial ruling last year. So a lot of these issues have been litigated completely in the first trial, and some have been litigated in part, and then we have more to it that's happening now. Mm-hmm. So basically with the ARCA experts, the defense wants to be able to say, we did not hire them, and there was a third party, and we want to not only say that there was a third party who hired them, but specifically the U.S. Attorney's Office. And they say they want to do that because leaving out who hired these experts initially is going to confuse the jury. It's going to result in some sort of bias against the defendant because she didn't actually hire them. The problem I think they run into is that they have now paid them, right? So it sort of crosses the line between, they want the ability to argue, we didn't hire them, we don't have anything to do with them, but now they have subsequently retained them. So it gets into a little bit of a gray area. From my perspective, I don't think she's going to change any rulings relative to reference the United States Attorney's Office, specifically now that we know, as it was announced in open court by Attorney Brennan, that the federal investigation is over. When you have investigations that have no outcomes, there's no indictments, there have been no findings, it often creates more confusion for the trier of fact, which is the jury. So I think it's unlikely she's going to let them reference that the United States Attorney's Office hired them. I do think there was an interesting request relative to sort of the parsing out of the fees. Yeah. They want to exclude the payments for voir dire because the fact that they had to have experts fly in really kind of pumped up the amount of the invoice that was paid for ARCA. And they want to say, we paid them for their expenses coming to testify last time, but not for voir dire, because when you look at a $23,000 bill, the jury might look at that and say, like, that seems like a lot. Are they just paying them to say what they want? And does that then prejudice the defendant, Karen Reed? So I think they have an interesting argument there as to whether they can parse out what specifically was paid for and what not. But I think it's unlikely they're going to be able to tell the jury that the U.S. Attorney's Office was the one that hired them.
And so on that front, it'll be very similar to the first trial in that the feds will just be this like imaginary third party that never gets named.
That's right. That's right. And it does, it's a difficult topic because it does create some sort of unknown, party to this, that the jurors probably feel like everybody's talking about something, but we don't really know what it is. But at the same time, opening it up, I think, is far more likely a can of words. And I don't think it's actually helpful in the inevitable question of whether she's guilty or not.
Okay. Okay. Next thing I want to ask you about is the defense is asking that the Commonwealth not be allowed to contact witnesses after they've testified. And they used some examples like prosecutors talking to Brian Albert during the lunch break after his testimony. What's that about?
So I think they should not be. No, if you have a witness on the stand, you should not be talking to them as whether you're a defense attorney, whether you're the prosecutor. You should not be prepping them in the interim. So I don't have any problem with that. It sounds like, from my recollection, I remember a little bit of the back and forth that Attorney Jackson, I believe it was Attorney Jackson and Brian Albert had about he and Adam Lally's discussion, and that there were some questions he mentioned. The question I had in the motion is just as to how it's written. I don't think there should be any objection from the Commonwealth based on the request for them not to have conversations while they're on the stand. But once they have been released as a witness, I think then that needs to be clarified. Are we talking about until the end of trial, until the end there's a verdict, or when they get off the stand? The victim witness advocate, generally is the person who, helps the victims and the witnesses sort of deal with how it works, what the process. So I would ask for clarification if I was the court as to when do you want this to end? Do you want this to be forever after they get on the stand, or is it simply while they're testifying and under oath?
Right. And there's a lot of criticism about this. So let's just clarify for our viewers, like prepping your own witness before they testify is pretty normal.
That's correct.
But it's talking to them kind of throughout the process.
Right. So you shouldn't generally, once you prep a witness, once they swear under oath and they get on the stand, the general course is that the witness is under oath and you should no longer be prepping them or really having any conversations further relative to the substance of their testimony. Once they're on the stand, and until they're released, then no real substantive conversations should be had.
Okay. And I didn't include this in my list to you, but I do want to throw out one other thing. There's a request from the defense to sequester witnesses, which I think happened last trial as well. But they mentioned specifically that like Colin Albert, Brian Albert, Jen McCabe came to closing arguments and sat there with the O'Keefe family, and they don't want that to be allowed in the second trial.
I don't know that the court will sequester them, but I think it's in the interest of the Commonwealth to advise those witnesses not to come. I do think that there's not technically anything wrong with it after they have testified, for them to come in during closing arguments. It's pretty regular in a normal case for victims and witnesses after they've gotten off the stand to come and watch the rest of the trial, to come and watch the closing arguments. The question here is whether it intimidated the jury or whether it had any effect. I don't think it helps the Commonwealth. I think it looks a little, if I were them, I would say just keep it to the family and let's not bring anybody else in. But I don't know that the court would order them not to come in.
Okay. Next up, we have competing motions, one from the Commonwealth to admit this evidence and one from the defense to exclude it. And that is the blood alcohol testing of Karen Reed.
So the blood alcohol testing, this is a motion eliminated that was litigated the first time. It was allowed in. For the most part, it's pretty much the same. The only thing that's different is the defense talks about that there has been a change in the procedures that the state police uses. So the extrapolation ends up going from I think in the first trial it was between 0.13 and 0.29. It was alleged to be at the time, 12:45, and it's now changed to 0.14 to 0.28. What their argument essentially is that since the state police didn't collect the evidence, it was a blood draw from Good Samaritan Hospital, that it does not comply with state police policy for the process of extrapolation and coming to a determination. I don't think that, one, they've never filed a motion to suppress, which is what would probably be the proper way to get this evidence out. And they've essentially waived it. I think they waived all their motions pending or possible motions to suppress at the end of the last trial date. And they also have, the Commonwealth also has the doctors from Good Samaritan Hospital who worked in the lab, who can testify as to the process of how that blood was drawn. So I think it's likely to come in again as it was the first time.
And that, for the jury, it's a pretty wide range, but it shows Karen Read's alleged blood alcohol level as it's calculated back to the time of the supposed crime.
That's correct. So when the blood is drawn at Good Samaritan Hospital in the morning of January 29th, I believe it's between 0.07 and 0.083 or 84, someplace around there. I wrote them down. So usually when I write them down, they stay in my brain. And so what they do is they take that number where she was at 9 o'clock and go back. It's a whole scientific process. They go back to try to figure out where her blood alcohol could possibly be at 12:45. And that's where they say it could be anywhere between 0.14 and 0.28, which is very wide. It's very wide, but the bottom level, 0.14, is pretty high.
Right. Still over the legal limit.
Right. Well over the legal limit.
Okay. Next up is something that was fully litigated during the last trial, but to be honest, some of my followers on social media seem really interested in this issue, so I'd love to talk it through.
Sure.
And the manner of death. So just a review is that on an autopsy report, there's a cause of death and a manner of death. John O'Keefe's cause of death was a combination of blunt force trauma and hypothermia.
Right.
His manner of death was undetermined.
Right.
And the medical examiner testified that that was because they couldn't make a determination between accident and homicide.
That's correct.
And
so generally,
out.
Right. And so what it really is, and I've had a lot of questions about this too, is it's not that so what the jury is supposed to do is use the facts and the testimony on their own. Basically, what this the statute actually says that you can't permit a cause of death when there's a question of liability. And essentially in a criminal case, the liability is, does it belong to Karen? Does the death of does the liability belong to Karen Read or somebody else? Mm-hmm. And it's really an issue for the jury to decide. So it's one of these sort of particular, whether it was homicide, whether it was suicide, whether it was undetermined accident, anything like that. It's not specific to this case that the Commonwealth doesn't want this jury to know that it was undetermined. But in any case, generally, the manner of death is redacted from the death certificate so that the jury can make the determination themselves.
Right. So the essentially prosecutors don't want the medical examiner to make that determination for the jury. They want the jury to decide.
That's correct.
And so allegations that this is like some attempt to conceal important evidence?
No. And I think it's important for people because it the second time around, obviously we went through a lot of this the first time, and some people, focused on different things the first time. And I think it's important to remember that this was already litigated the first time it came in, and there's no ill intent behind it. This is standard normal course for these types of cases.
Right. And you mentioned it did come in during the first trial.
Right.
Okay. What do I have next? We're getting there. Okay. This was also litigated during the last trial, and then it never ended up coming to fruition. That the defense says that they might call Norfolk County DA Michael Morrissey to the stand. And then the prosecution says, well, you have to offer sufficient proof as to why you need to call him. What is that about?
So it'll be interesting. We haven't seen a witness list from either the defense or the Commonwealth yet. So we don't know if they actually intend to put Michael Morrissey on the witness list.
Yeah.
It was really my position the first time around. And I think if he's on the list the second time around, that it was a little bit more for the sort of public perception of it as opposed to actually the likelihood of calling him. When, the case law about calling a prosecutor is that you have to show that there is good cause, you have to make what's called an offer of proof to the court. So basically, if you say, I'm going to call this party Michael Morrissey, and there isn't a clear apparent reason as to why he would testify or what the relevant evidence would be, then the party who intends to call them has to go to the court and make a good faith basis offer of proof and say, this is what we believe will come out from this testimony. I think it's unlikely that they'll call him. I think it was unlikely they were ever going to call him the first time. The same thing with victim witness advocate Steve Nelson. But I don't think it's an unreasonable request if they do come in court and say, we do intend to call him. I think it's fair for the Commonwealth to ask for an offer of proof.
Okay, I'm going to move on to the next thing, which is we've talked a whole lot about the 227 Google search on Jen McCabe's phone. And it appears in these motions that the Commonwealth plans to call the same phone experts. However, they now want the court to let them do a demonstration on phones for the jury. What do you think about that?
So I think basically it was allowed the first time. It's, again, the motion was filed the first time, and then we have another paragraph relative to Jessica Hyde doing a demonstration. I don't think it's unreasonable when we have experts who testify in very specific, complicated areas of the law. It's within the judge's discretion to decide whether it's appropriate and would help the finder of fact. And I do think that given how technical some of this evidence is, much like the defense asked for the state police technician to use the demonstration about where the pieces of glass were found. Yes. I think it's reasonable for Jessica Hyde to use some sort of demonstrative aid to explain what the findings actually look like. And really what we want is anytime a party is introducing evidence, whether it's the defendant or whether it's the Commonwealth, if there are aids to sort of simplify some of these complicated issues, I think it's always helpful for both sides.
Okay. This next one, to me, seems like a big one, especially because it didn't exist for the first trial. Tell me if you disagree. The Commonwealth is asking the court to prohibit any reference to internal affairs investigations into officers involved in this case, of which we know there are at least 3 that I can think of, some of which are closed and some of which are still open.
Yeah. So I think it actually was, I have it written in my notes that it was filed the first time. I don't know if it's exactly the same because I didn't compare them directly. I think it's
I just know a lot of these were launched after the first trial. Right.
So again, similar to the discussion about whether the federal reference to the federal investigation can come in, anytime you have an active or ongoing investigation, it's generally not going to be admissible in court. Now, if, for example, we have obviously the number one, Trooper Proctor, who has been suspended without pay. He's been before the tribunal board, and he's in the process of likely being disciplined. However, there has not been a finding as to any disciplinary actions yet. And so generally, unless and until there is a finding of some sort, the idea that you can sort of just reference these ongoing investigations, again, it serves often to complicate things for the jury instead of clarify. And so that's really what it comes down to is how much does this help? And can it be used in the circumstances if there has been no finding of wrongdoing by anybody?
Okay. I feel like the natural next question, just as a curious person, is there any chance that Proctor's disciplinary hearings are going on so long for a reason connected to this? I mean, people expected them to be a day, and we're about to head into day 3 tomorrow.
Right. If we're being cynical, yes. I mean, I don't think that it's not surprising to me in terms of like the politics of it. I don't think that the state police, I think he's likely to be found responsible for at least some of the charges against him. And if he were to be found responsible prior to the hearing, then he could likely be questioned on that. So I'm not surprised that the decision on his disciplinary proceedings will likely come after the trial is over and after he's off the stand.
Okay, so you don't think we'll find out the outcome of his job before this trial?
If I was a gambling woman, I'd say no.
Wow. Okay, interesting. Okay, I'm trying to make sure that I have enough time with you because I don't want this meeting to turn off. Sorry to anybody who's watching this on YouTube.
I know, it always cuts me off at 40 minutes.
I know, I'm just trying to check that I have it on long enough. Is there a way for me to even do that? I don't know. Okay, let's just fly through the rest.
Okay.
Okay, this next one also pretty interesting to me. The Commonwealth wants to omit any witness prior bad acts or reputation evidence. And there's one quote in their motion that I would just love to read. This is written by the Commonwealth. It says, at the previous trial, the defense lodged a slew of claims of alleged bad acts of witnesses. The defense has engaged in a comprehensive campaign to inundate the public with its claims. Declared or implied that the Commonwealth prosecutors, court, trial court employees, and witnesses are corrupt and all part of a cover-up of evidence. This seems like a pretty wide-reaching motion, no?
It was, and for me, it was a little bit difficult because we're not really parsing out what specifically, what witness, what did they allegedly say? You know, the general idea, there was also a defense motion for exclusion of prior bad acts relative to Karen Reed's behavior in Aruba. But the general idea about prior bad acts is that they're inherently prejudicial and usually admissible unless there is another way for them to come in. Because really what prior bad acts do is they put a bad taste in the jury's mouth of a particular person, and then that sort of taints the way they're looking at the defendant in front of them or the witness in front of them. And what we want is for the jury to just look at the facts and evidence in the case that we have at hand, so that they're not confused or distracted by whether it's Karen Reed's behavior elsewhere or whether it's one of the witnesses' behavior elsewhere that doesn't really have to do with anything in this case. So I think it's a fair request, but I think it has to be passed down a little bit because it is so broad. If they had specific, witnesses or specific allegations that were made last time, I think it would be easier for the judge to rule on that. So she might ask for some specifics before making a decision.
What would count? And I know you're saying they didn't say specifically, like I'm thinking about those like Colin Albert videos where he to fight people. Does that count?
Well, I mean, that's tough because in a way that was really more impeachment evidence. I mean, that's the problem for me is that with that motion, I'm interested to see, do they mean specifically questions that the defense asked while witnesses were on the stand? Certainly there has been a lot of allegations and sort of mudslinging in pre-trial hearings before the court, but I don't know specifically what they're referencing that happened at trial. Most of the stuff that came in was proper. So that's why I think if Brennan wants that ruling, he's going to have to specify.
Right. Okay. Two more things. Third party culprit. This was the defense's whole case in the last trial. Is it going to be again?
So I am wondering whether it's going to be. I think it will in part. I don't know if it will be in the same level. The interesting thing that the Commonwealth, they asked for them not to, they asked for the third party culprit defense to be kept out the first time. And basically what the judge's ruling was, at this stage, we don't have enough, but I'll allow you to develop it as we go and sort of piecemeal it. But you cannot open on it. Obviously, we know that David Unetti opened on Karen Reed's frame, so sort of went in direct contradiction of what the ruling was. And they began to develop some of it through testimony. From the Commonwealth's perspective, they say, despite all the pretrial litigation, despite the interviews the defense and the defendant have given in trial one, there actually hasn't been anybody who has been singled out specifically as to, we think this person did it, and they had the motive, means, and opportunity, which is what you need to show to the court to be able to present this defense. So I think because it came in the first time, she's probably going to allow them the same leeway, but we'll probably have a more stringent recommendation about what and what cannot be said during opening.
Interesting. Okay. And then the last one I had on my list before we get to my catch-all question, and I'm hoping this Zoom doesn't turn off in 15 minutes.
Fingers crossed.
If it does, I'll just send you another link. This is like the newest allegation from the defense, which is they want no contact with jurors from state police or anybody from the Norfolk District Attorney's Office.
I mean, That's, I mean, unless there's incidental contact, there should be no, this is like par for the course. We shouldn't have to ask for it. I don't think there have been any actual founded allegations that anyone from the Norfolk DA's office or from the state police actually had interactions with the jury. Obviously, we know it was brought up in the motion to dismiss about Trooper Fanning, Lieutenant Fanning, but we don't know how
the judge adamantly denied was true. She said the only people who have interacted with the jury are court officers.
Well, so I took it as two separate things. The jury, when they referenced in the motion to dismiss that Fanning was in charge of the jury, I mean, that's patently false because it's not within the purview of the state police. That's only within, the control of the trial court and the court offices. Yeah. So I think she was upset because, Attorney Yannetti knows and any Massachusetts knows the state police are not in charge of the jury. Whether information that Trooper Fanning provided to the court officers relative to the juror who was dismissed at sidebar, we don't know the specifics of how that information came to him. So I don't think we can say for sure a juror went to Trooper Fanning. All we know is that he had that information. So it could have come, it could have been hearsay on different levels. Obviously, there wasn't further inquiry, so we don't have any specifics to that. But I think the Commonwealth can agree that it's within their obligations not to. I mean, you're not allowed as a prosecutor, as a defense attorney, anybody. If you ran into a juror in a bathroom or a hallway, you don't even make eye contact with them. You look away. So yeah, you'd be violating your oath if you were to do so. So I don't think they need an order for that.
Okay. It looks like my Zoom length survived. So this is our viewers on YouTube. Are there any other motions in here that stuck out to you that we didn't talk about?
Let's see.
And we talked a little bit about Aruba, but just so our viewers know, there was all this testimony in trial 1 about this incident in Aruba where Karen accused John of kissing another woman, and the defense is asking for that whole incident to be excluded, essentially.
And I think I actually think it's fair. I think it's pretty remote. I thought it was last time. So generally when we talk about this type of evidence, what the Commonwealth is trying to do is they're trying to establish a pattern of conduct and behavior and the nature of the relationship between John and Karen. And that really only goes to the second degree. We don't need to get into the mind and or what her mental status was for the second degree, which is the manslaughter. So I think it's actually a reasonable ask. It was allowed the first time they were allowed. It was the Commonwealth was allowed to inquire of those witnesses, the Sullivan sisters, but I think it's pretty remote. So I think it's reaching for the Commonwealth.
I do think a lot of people have also just anticipated that would be left out of the Commonwealth's case.
I think so, because it didn't. I don't think it. I understand what the intention was of ADA Lally trying to put it in, but I don't think it landed. Yeah. And it seems to be a distraction, if I'm being honest. So I don't think it's necessary.
Yeah. Anything else?
I don't think so. I have my big book here, my binder full of motions and limine. But yeah, it'll be interesting. I expect maybe we'll have some more, but I don't know if we will or not. But we're gonna have a busy week next week.
And there's probably going to be rulings before the hearing Tuesday, right?
I would think so. A lot of these were, standard requests. We're talking about jury voir dire. Last time she allowed individual attorney-led voir dire, but not panel, going for review, things that are often filed with almost every case, specifically a superior court case. So anything that can be decided on the papers, she's going to issue decisions on to limit what we have to talk about next week.